Welcome back, everyone. This is the final session of the Florida Federal Con Law Review with Ibis Prep, and I'm your host. My name is Andrew, and I'm here to help everyone pass the Florida Bar Exam, Part A. So we're going to just resume where we left off, which was looking at different Florida and federal common law essays and getting a good feel for what issues are commonly tested and what we should look out for. So let's talk about I guess this one for a reason. There might be some family law issues implicated. I'm sure there are going to be. I don't want to talk too much about the family law issues. I want to talk about the other issue. Okay. Wanda Woods comes to your office for help with the following debts. Let me jump to the conclusion. Please prepare a legal memorandum discussing the interest each party holds in the subject property. In your memo, include an evaluation of the title, possible claims against the property, and her offer to pay your firm. So maybe this is a real property question. Maybe this is a family law question, but I kind of want to focus on the obvious homestead issue. Okay. Wanda Woods comes to your office for help with the following debts. After an interview and review of public records, you discover the following. Wanda Woods lives in a mobile home on 6 acres of property in rural Citrus County. If that's not like a hello, ring, 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 homestead exemption, I don't know what could be. You're talking about rural and acreage and home. Like, they do really tee up a lot of these things. They sneak some of them in there, like the impairment of contracts issue on the last one, but they tee up a lot of them, like this homestead issue. The recorded deed to the property is in the name of Wanda's father, Frank Woods. Frank Woods died in 1990 without a will, leaving behind his wife and their 2 daughters. When Molly died intestate in 2001, Wanda had already moved out. Sally still lived at the home. Molly had healthcare bills totaling $10,000 when she died. Sally moved out shortly after her mother died. Wanda was living in an apartment at the time, but she was evicted for non-payment of rent, and a judgment for $3,000 was entered against her and recorded in 2003. Wanda then moved into the mobile home by herself. So why is this all important? What is this getting at? I told you it's homestead, and that's why I want to look at it. It's getting at whose homestead is it, right? And what's the requirement for a homestead? Who can claim a homestead? And how many homesteads can one person claim?
Only one, and it has to be, and only a natural person can claim it.
And what is your homestead?
Has to be
Your primary residence.
Right, where you live and tend to reside. How many months out of the year do you have to live somewhere for it to qualify as a homestead?
At least 7.
6.
Yeah, more than 6. That's it's not set in stone, but usually if you live somewhere more than 6 years, 6 months, it qualifies your homestead. If you live somewhere 6 months and another place 3 months, the place you lived at for most of the year will qualify as your homestead. Okay, in 2004, Wanda married Howard, who moved into the mobile home with Wanda. Wanda went to the banking company in 2005, borrowed $20,000 secured by a mortgage on the property, and used the proceeds to make repairs to the home. What's important about a homestead and a mortgage?
The mortgage can pierce is one of the creditors that can pierce the homestead exemption.
Right, and someone even asked about this in my Telegram chat, which was Howard never signed the mortgage, so both of them paid on it. So can they foreclose on it? This is definitely where they got this question from, and it's we can write about it that probably not. It's probably their homestead, and the mortgage is attached to whoever signed it. And if one party didn't sign it, then it's not personal to them, and therefore they're going to have a hard time foreclosing on the other person's homestead. But again, it's a conversation we could have. Wanda still lives on the property with her 2-year-old son, Sammy. So Wanda and Sammy still live on the property. It's going to be their homestead, right? Banking company has now filed a foreclosure complaint against Wanda. Wanda has someone who's willing to buy the property for $150,000. She offered to give your law firm a mortgage on her interest in the property in lieu of cash payment for legal fees. That's an ethical issue. We'll talk about that later. So this is really homesteady. It's as homesteady as it can get, which is what I wanted. And I just kind of want to look at the model answer so that we're like prepared for a homestead essay. Under the Florida Constitution, natural persons who own Florida property and make it their primary residence are entitled to homestead exemption on 1/2 acre of land inside municipalities and up to 100 contiguous acres of property outside the municipality. The homestead protection is for land and property owned by the parties and may include apartment and condominiums, but a mobile home, as in this example, may not carry the permanency of the land required for homestead, since a mobile home can be readily mobile. Interesting point. We were talking about a mobile home here. Under these facts, however, it seems that the mobile home is a homestead, right? So again, point to make, like, is a mobile home a home only if it's permanently affixed to a certain spot, which this case it was. But me being someone who loves getting points, let's take note of that and recognize that. It's important to note that it's a mobile home because it's not necessarily a homestead. It has to be permanency. Under these facts, it does. Homestead protects the property from claims of creditors as long as those claims are not related to the land. Claims such as mortgages to purchase the home or improve the land are related to the land and therefore exempt from homestead protection. However, third-party judgments not related to land, such as judgment for accidents and personal loans, cannot be satisfied by placing a lien on the homestead property. The remedy of such creditors remains to be satisfied either personally, by the debtor, or through non-homestead property. Homestead also seeks to protect the family. Under homestead, a homestead property automatically inures to the family of the deceased, regardless of a will or other bequest provision to the contrary, and regardless of whose name the property is titled under. If there's a surviving spouse and surviving minor, the property passes to the spouse as a life estate and to the children upon death of that spouse. Here, if Frank's house was the homestead property, automatically passed to Molly for her life upon Frank's death. The facts indicate that while Wanda was 10 and Sally was 8 when Frank died, and as minor children, they would obtain the rest of the estate upon the death of their mother. If Molly's hospital obtained a judgment against her, the hospital would not be able to attach a judgment on the home because the homestead property would be exempt from judgment of creditors not attached to the land. However, if Molly left any money behind, the hospital bill would be satisfied from said assets after paying the funeral expenses. Again, like I just, and it's the nature of time, I'm trying to get through multiple essays today. I wanted you to read about homestead exemption. That was pretty beautiful. Talked a lot about homestead and who can pierce it and what it covers, and also talking about the permanency of it. And then also speaking about how it'll automatically pass to the heirs of the land. They talk about them being tenants in common. We'll talk more about this in real property. I want to talk about homestead exemption. The facts state that the creditors obtained a judgment against Wanda for unpaid rent, which was recorded in 2003. In order to qualify for homestead exemption, the party must own and make the homestead property their primary residence and should claim the property as homestead before the creditor liens attached to it. Wanda owns the property along with Sally. The judgment was entered and recorded in 2003. Wanda will argue that she's entitled to homestead exemption for the $3,000 credit because the judgment was for a credit that did not concern the mobile home, and as such, the landlord should not be entitled to put a lien on her half of the property. The other party will argue that Wanda was not living in the home at the time the judgment was entered and therefore is not a permanent residence. And they will also argue that she did not claim as her homestead before the judgment attached, since Wanda moved into the home after the judgment was entered, making the home susceptible to the claim of a landlord judgment against her. The creditor in this claim is likely to succeed against Wanda. I mean, they were talking about a lot of things, but ultimately, because it was on the property, right? It was unpaid rent, which was recorded in 2003. The creditor is likely to prevail, they're saying, because the creditor's argument was that did not concern the mobile home. It was personal. So maybe they're likely to succeed. Wanda is entitled to complete use of ownership of the land for an undivided 1/2 interest. She would be entitled to place a lien on her 1/2 property even without Sally's consent. However, if Wanda and Howard made their interest in the property their homestead, it does not matter that Wanda held title to the property in her name only. Howard would still have to consent to any encumbrances on their half interest in the land, making the encumbrance invalid against the property. So this is getting at, you can't make an encumbrance on a property if it's someone else's homestead. You need their consent. You need the consent of the spouse if it's their homestead. The bank also talking about notice, mortgages, interesting things right here. Talking about equitable redemption. I'll talk about this in property law. Like this is mislabeled. This is half of a real property question, but it's also a lot about a homestead exemption. And I just really wanted you to understand how it could go on a Florida essay question. It could be literally entirely homestead with just a little bit about mortgage and foreclosure. But this was really just understanding a homestead exemption. And if you could recognize as a homestead and talk about how that would affect the interest, then you do pretty good on it. Half an acre inside municipality, 160 contiguous acres outside. It's going to be protected against judgment creditors, but not for creditors related to the land. And it'll pass automatically to your wife or your children. And the other thing was that you need the consent of your spouse if you're going to have an encumbrance on the property. So I just wanted to show you all that Florida common law goes in a lot of directions, but sunshine law, homestead exemption are particular to Florida, and they're so particular that Florida sunshine law is tested often, and homestead exemption is tested very thoroughly, and it could be like the only thing tested in an essay. Pretty good. So in the spirit of time, I want to kind of look at some federal common law essays. Maybe they'll also implicate Florida common law as well, but let's just kind of take a look at them and see what happens. It's weird because this is federal common law, but definitely has some Florida common law issues. But let's talk about it. Amy, do you mind reading this first paragraph?
During its last session, the Florida legislature passed a bill banning all advertising in Florida of citrus grown outside the state. Legislators who supported enactment of the statute gave two reasons for supporting the bill. First, many legislators cited examples of some out-of-state citrus growers making false or misleading claims in advertising that Florida citrus was treated with more harmful pesticides than citrus grown outside Florida. Second, the advertising ban would give a competitive advantage to Florida citrus farmers who were at risk of going out of business after an unusually cold growing season.
Okay, good. I just wanted to, I wanted to go back to and read the call to question. Memorandum analyzing whether Farm Co. can bring a successful lawsuit to have the statute declared unconstitutional based on the United States Constitution. Okay, so it is federal common law. But again, federal common law incorporates, or Florida common law incorporates the federal Constitution. So with that first paragraph, anything you saw or issues that you might be alerted to? Florida legislature passed a bill banning all advertising in Florida of citrus grown outside the state.
First Amendment.
Definitely.
For regarding the banning of all advertising.
Mm-hmm. I mean, and definitely how false or misleading commercial speech is not protected, but maybe all advertising. What does that sound like? All advertising?
Overbroad.
Could be overbroad, could be vague. We're always going to talk about vagueness and overbreadth. That's like the theme of the day. So, go ahead.
I was going to say, I would say that the advertising, it's talking about out of state, in state, so Commerce Clause and Dormant Commerce Clause, maybe.
I think I agree. Commerce Clause, Dormant Commerce Clause, maybe privileges and immunities. There's definitely something here about out of state going on. Already probably thinking about due process, equal protection, but First Amendment was definitely a big one. A legislator passed a bill. We talked about passing a bill. What's necessary to pass a bill?
It needs to be read 3 times and needs to be about a single subject.
Bicameralism and presentment.
Yep, bicameralism, presentment, and that sounds good. Okay, so we're going out of business after an unusually cold growing season. It would give a competitive advantage to Florida citrus partners. Okay. I think we'll talk about scrutiny levels here and things like that, but definitely a lot we see from this first paragraph. The bill was signed into law shortly after its passage by the legislator. So we're going to go into sign into law, enactment, same thing, same bill, enactment, what needs to happen. The new statute, titled the Florida Citrus Grower Protection Act, so that's its title, provide that a violation was a second-degree misdemeanor. What does that sound like?
Encroachment?
Maybe.
That they have to be uniform with when it comes to criminal law and criminal punishment.
Yeah, I mean, I might think bill of attainder, right? It was a second-degree misdemeanor. We're just punishing people for violating this statute immediately. Yeah, I don't like that. I would say bill of attainder, but a violation was a second-degree misdemeanor. I like what you're saying, that it's not going to be lawful for this to be a violation of a civil act to be something criminal. I would definitely say bill of attainder. Due process, I'll talk about, because you need notice and hearing. That's even better than bill of attainder. I would say it's a violation of due process to say that this is going to be a misdemeanor just because you violated the statute. You're not going to have notice and hearing. Procedural due process, substantive due process, equal protection, bill of attainder. We can go at it from a lot of different angles, but it's always the same tools in your toolbox, right? It's how I want you to think about con law. You have these tools in your toolbox to attack with, but they're the same 10 or 12 tools. You just need to know what they are and how to use them. All right. Joel, you mind reading this one about Farmco?
All right. Farmco, a large commercial grower of oranges in California, has contacted a senior partner at your law firm to discuss challenging the statute on constitutional grounds. Farmco has never advertised its oranges in Florida, but had been in negotiations with local radio and television stations in Florida before the statute was enacted. Based on its success in other areas in the country, Farmco projects that its radio and television advertising campaign would increase its sales in Florida. However, with the new statute in place, Farmco has halted any plans to start advertising its oranges in Florida because it is afraid of being criminally prosecuted.
Okay. So don't tell me about civil procedure, because they're not asking about civil procedure here. You know that, like, they're saying about U.S. Constitution. I want you to get into, like, I don't even know what, diversity or something. But what are they talking about here?
Impairment of contracts, maybe.
Okay, I like that. What else? Yeah, definitely impairment of contracts. Definitely impairment of contracts. So this one had bill of attainder and impairment of contracts, which kind of, off the beaten path a little bit. But definitely there's a lot of due process, equal protection here. But what else does it seem like?
I mean, I think I had already said it before, but dormant commerce clause, maybe.
Mm-hmm. What do I always say we should start off these essays with? What 2 things? I said standing, and even more precisely,
justiciability.
Yeah, justiciability. Right. Does anyone think this is talking about ripeness?
Yeah, because it hasn't been enacted yet, so it's not ripe.
Before the statute was enacted. Does everyone see that? Does everyone think they would have got that? Ripeness is I mean, I'm not positive. We're gonna look at the model answer, but it seems to be ripeness here.
Or I guess maybe it's moot because they stopped their negotiations before it was enacted.
Yeah, maybe it's moot, maybe it's right, exactly. But either way, I think there's a discussion there. So vagueness, overbreadth, justiciability, standing, due process, equal protection, um, freedom of speech, right? First Amendment, um, unprotected speech and first protected speech. I think I said vagueness and overbreadth again. And anything else? Oh, impairment of contracts, bill of attainder, procedural due process, notice and hearing, Florida enactment, bill versus law, right? You see, there's tons of issues we could spot. And in my first few classes, I went kind of slowly and showed you how I spot these issues, turn them into IRACs. I'll do something like that again, before class is over. But this is about issue spotting, Florida common law issues. Let's see what they spotted. Right? Initiate sue in the first place. What does that sound like? Whether they're going to have standing. Talking about suing the state too was important. Let me circle back to that, because if they're suing the state, it would have to be some sort of sovereign immunity piece. So Farm Code needs standing. This would be a federal question. They could bring suit in Florida, a court of general jurisdiction. The state of Florida cannot self be sued in federal court, but it can be sued in state court. Client likely wants to sue in federal court, which is likely to be more receptive. The bill here has been signed into law and therefore will be enforced, presumably by some administrative or executive agency or official. They can be sued in federal court so long as no money is requested to be paid from the state treasury. So this was a lot about suing the state in general, which we didn't really mention, but we should talk about. And they're saying that they could bring suit in Florida in federal court potentially. So the bill here was signed into law and therefore will be enforced, presumably by some administrative or executive agency or official. They can be sued in federal court so long as there's no money requested to be paid from the state treasury. But the statute has not yet been enforced against our client. This raises the more critical issue, thankfully, of justiciability and standing. That was the last thing we talked about, but it's very critical. A plaintiff must have standing to sue. Standing requires injury in fact, causation, redressability. Here, causation and redressability are more easily satisfied. The statute at least arguably has caused or seen to have caused client not to advertise in Florida, and the court can redress the injury with declaratory relief regarding the constitutionality of the statute. So remember, I said we always want to start off with standing and justiciability. That's exactly what they did here. But it's unclear whether they suffered an injury. However, because this case raises First Amendment issues, courts apply a lower bar to causation. Laws that prospectively prevent speech and are challengeable where the injury is apparent, quo, chilling speech, or likely to occur. The statute here directly targets our client and prevents speech client otherwise would have made, as the facts state that the statute has chilled speech and the client has decided not to halt advertising and fear the statute. So they're talking about this almost being like a gag order and like proactively preventing speech, but whatever. I'm more focused on issue spotting, justiciability, standing, First Amendment, doing good. Okay. Ooh, they could also raise tortious interference with the business relationship, which I think you were more talking about impairment of contracts. But from a torts angle, maybe that is a thing that they could, but they said it will fail. But still, they're reaching for that. So let's talk about more importantly what they were really getting points for. They were getting points for this First Amendment piece. The First Amendment protects the freedom of speech. Economic speech, such as advertisements, has long been recognized as protected, unless it's inherently false or misleading. Right? We talked about that. Protected speech, but not the false or misleading. All other speech, they're saying must meet intermediate scrutiny, which means the government must be important and the law narrowly tailored to achieve those ends. They meant to say strict scrutiny. It should be strict scrutiny on commercial speech, unless it's false or misleading, then it's a lower level. The court cannot inject its own reasoning into the analysis. The government bears the burden to establish the importance of the interest and narrowly tailor that law to the interest. So the statute here likely fails on all accounts. While false or misleading claims in advertising are regulatable and may be completely prohibited, the legislator has not advanced that all or even most or even some significant percentage of the state advertising regarding citrus is false or misleading, right? If you go back to the question, it says that they cited that some out-of-state citrus makers are false or misleading. But it's like we said, it's going to be overbroad, and it's going to be infringing upon First Amendment just because some is false or misleading to regulate everything. So we can kind of get through it, but big First Amendment thing. Also violates privileges and immunities because it discriminates against out-of-staters. We mentioned this. We talked about privileges and immunities, Commerce Clause, Dormant Commerce Clause. Let's see how they got their points here. The statute likely also violates privileges and immunities because it seeks to discriminate or distinguish on the basis of in versus out-of-state residents on the issues of economic activity and livelihood. States may not discriminate on the basis of state residents absent a compelling and legitimate governmental interest, and the mechanism employed is narrowly tailored and required to achieve that end. This law clearly does that, and discussed above, it's not compelling and means are not proper. Only a real person, right? Does everyone know that? Only a real person can raise a privilege and immunities claim, not a company. It's possible that farm code is a DBA and the real property is an individual. Just something to take note of. Only an individual can raise privileges and immunities. So too, only an individual can raise a Fifth Amendment right against self-incrimination. There's some things that are personal, privileges and immunities, and right against incrimination. Interstate Commerce, that was a really great thing that you mentioned here. Now that I'm looking at it, I think this one also might have a commandeering issue. Is it the federal government forcing them? No, not really. Okay. So going back to this Commerce Clause, that was, Joel was all over that. The statute further raises the issue of regulating interstate commerce, advertising for sale of citrus from one state to another. The federal Constitution empowers Congress and the federal government to regulate commerce between the several states, between the U.S. and foreign states, and the U.S. and Native American tribes. There's no indication that the federal government has spoken directly on the issue. Common knowledge would implicate the Supremacy Clause as well, which provides that federal law is supreme vis-a-vis contrary law or state law requiring abridgment of the federal law, where the federal law is an area properly within federal power to act, such as here regulating interstate commerce. Regardless, the state statute implicates the Commerce Clause, even where the federal government is not spoken, by the Dormant Commerce Clause, which was mentioned by Joel, because it seeks to regulate interstate commerce and distinguishes on the basis of state residency versus in versus out of the state. A state statute violates the Dormant Commerce Clause in such context if it fails to meet the rigorous strict scrutiny tests above. And as discussed above, economic protectionism, at least where the state is not a market participant, is not a compelling interest. Neither is the false advertising issue here, which is not properly tailored. So they talked about the Commerce Clause. Then again, we talked about this is good. Joe, you're all over this. Also implicates the Impairment of Contracts Clause. The federal Constitution prohibits a state from passing a law abrogating private contract rights. However, to fall afoul of the Contracts Clause, the contract needs to be in existence. A state law is not violative if it prevents the realization of future and not yet existing contracts. The facts here recite that client is in the negotiations phase. This suggests there's no contracts for advertising yet, making this a poor basis for suit. Do you see, though, it's not about winning or losing the argument. It's all about recognizing the issue, talking about Contracts Clause, talking about Commerce Clause, talking about privileges and immunities, talking about First Amendment. That's what it's all about. The issue spotting and the rule recitement. Whether or not you come to the accurate conclusion is less important. Equal protection, certainly. Laws that categorize and provide differential treatment on the basis of these categorizations are suspect. However, laws that categorize on economic basis, for example, are rational basis review. The law does discriminate on the basis of state residency, but subjected to rational basis review, would likely pass muster. Preventing false advertisement and providing economic support are reasonable governmental interests, and it would lose on those ends. So it would not be a strong basis. So they're saying it's not a good suit, but it's still suit. Taken together, Farm Co has a strong basis to sue an appropriate government defendant in appropriate forum for violating its First Amendment rights to free speech and for violating the Commerce Clause and or Dormant Commerce Clause. May, if the facts allow, raise a privileges and immunities claim, but will be unlikely unable to raise an equal protection or contracts claim to declare the statute unconstitutional. I think the one thing they missed here was more of a due process discussion. procedural due process and substantive due process, but they did a good job. Also vagueness and overbreadth. They didn't talk about those two things. And also they didn't talk about enacting a bill or law in Florida, right? This wasn't a totally complete essay, but it was a good essay that really talked about the First Amendment claims and the Commerce Clause came, and they did a good job at the beginning, certainly talking about standing and ripeness, right? A lot from this essay. They could have written a better essay, but I thought they wrote a really good essay. Let's continue on with federal con law, or Florida federal con law. Did that one.
Andrea, I got a quick question about that one. Just can you go back to the model answer of I think it was on like the first paragraph pretty much, because I'm just looking here in my Florida con law outline. I have here that Florida has waived sovereign immunity for operational decisions. So I'm not exactly sure how that would, I guess, implicate the 11th Amendment. What are operational decisions, I guess?
Well, it's waived sovereign immunity in a couple circumstances. It's waived it in tort law. It's waived it where you can sue an individual, like a
individual capacity.
And for operational decisions, is that what you said?
Yes.
I guess that would mean like the decisions that are made by state officials in an operational sense, in terms of how the government's going to be run or how different pieces of the government are going to be run. So if they do something that's a decision that's negligent, then they can be sued in that capacity. I don't know if that super applies to this one, but also for tortious interference, they said, oh, no, that was different. But yeah, I think that whether they could bring suit in the first place, how talking about the concept of sovereign immunity and then saying that it was probably waived here. Again, when you're doing an essay, you don't want to just be like, it's impossible to sue the state, therefore my essay is finished. Try to assume that they do have standing and, they satisfy these elements. Standing, injury in fact, causation, redressability. That was very important. And then whether it being, what did we say? That it was not ripe yet. I'm trying to see where they talked about the ripeness of it. It was at the beginning, right?
I think that they put that in the contracts clause part, saying that they were still in negotiation phase.
Yeah, exactly. Right, that it wasn't necessarily ripe yet. No, I thought they talked about that too at the beginning though. I'm sorry. That like the statute has not yet been enforced against our client. This raises a more critical issue of justiciability and standing, right? They didn't really mention the word ripeness yet, right, but I think they should have. So again, this wasn't like the most perfectly written essay, but it was solid enough to get the model answer. So let's talk about this one, driving under the Influence Prevention Act, known as the DUI. Let's see. May, are you able to read this?
Yeah, I can read this. Okay. Right. The United States government has enacted the Driving Under the Influence Prevention Act, known as the DUI. The statute directs the Department of Transportation to reduce a state's federal highway funding by 10% unless the state requires all men under age 34 to take an 8-hour course about the dangers of drinking and driving before obtaining or renewing a driver's license.
Okay. First off, I want to read the call to question. Prepare a memo that discusses all the issues raised by Dua Lipa under the United States Constitution. For this memo, assume that they have standing and do not discuss the 21st Amendment. So you don't have to discuss standing and the 21st Amendment. Anyone know what that is?
It has to do with alcohol. like restrictions on alcohol or something like that.
You're right. That repealed the 18th, which was
prohibition.
fish.
So
Right.
either way, if they tell you just definitely not talk about something, don't talk about it. So again, they're just telling us to see constitutional challenges of the Dua Lipa Act. And when we look at the first one, May, what did you think that may have brought up?
Probably intermediate scrutiny review, because it's the funding is or this regulation is only targeting men. You can also talk about the, I guess, like the spending power and the like how Congress can condition their funds based on particular, like they can
taxing and spending. So 16th Amendment, that they can tax and spend for the health and welfare of the people, and they have broad taxing and spending powers. And then the other thing that you were mentioning was conditioning funding based on certain requirements. What is that underneath? Does anyone know? Commandeering, yeah, it sounds like a commandeering clause issue. In this situation, is the federal government commandeering the state to compel them to do something? Or are they simply inducing them by reducing funding?
It's commandeering because it says requires.
Mm-hmm. It directs them to reduce this by 10% unless the state requires. So it seems like it's a question whether it's compellment or inducement, but it's definitely commandeering.
I was gonna say I would think it would not be, because it's like they have a choice.
Right.
They cannot receive the funding.
I tend to agree with you, but again, issue spotting. We can see this commandeering clause.
Yeah, I see it both ways. And
commandeering is always going to be with preemption, federalism, supremacy, 10th Amendment, those types of issues. Would you be able to, I guess maybe counter argue that, say that it would be unconscionable and they would have to agree to the terms? And so it is. Right, that because, the 10% is so severe that it's not just inducing them, it's more or less compelling them. That's definitely an argument. Hands are tied, right? Their hands are tied. Yeah. All right. In support of Dua Lipa, Congress found that I'm so proud that I know who Dua Lipa is. Congress found that even though literally someone told me to listen to this is Dua Lipa, and I'm like, no, this isn't. This is literally Elton John. And they're like, what? I'm like, all right. Congress found that driving under the influence interferes with the United States government interest in providing safe travel on interstate highways. So they found that driving under the influence interferes with the United States government interest in providing safe on interstate highways. Okay. They're talking about the reasoning for this act, right? So they're targeting men. We talked about that intermediate scrutiny, and they're giving their reasoning for it. So, whether it's rational basis or intermediate scrutiny, it's just kind of their argument. And maybe it's right to travel too. I don't know. They said that. I don't know if that's going to be coming up, but I'm thinking about that. It also found that alcohol-related crashes substantially affect the national economy by increasing medical costs for injured persons, car insurance costs for all drivers, and law enforcement and emergency costs for local governments. These findings were based on studies by the National Transportation and Highway Safety Administration, which yielded the following statistics. Okay, just kind of give us some statistics here. In 2018, I hope these are real statistics. Not like I'm a favor of DUI. I just think it would be weird if it gave us fake statistics. In 2018, 1.8 million Americans were involved in crashes in which a driver's blood alcohol content was above 0.08. In 2017, drivers under the age of 34 were responsible for 67% of fatal DUI crashes, even though drivers under age 34 comprise only 34% of drivers. Oh man, I'm so close to getting out of that bracket. In 2 years, in 1 year, I will not be in this bracket. In 2017, men were responsible for 80% of fatal DUI crashes, even though men comprise only 50% of drivers. All right, they're really I feel like a woman wrote this essay, but I don't, just joking. Okay, several members of the Florida legislature have stated publicly that passing a bill to implement Dua Lipa is a top priority. The president of the Florida Senate told a local newspaper, "We would be crazy not to pass this bill. Federal highway funds are the source for 30% of the Florida Department of Transportation's budget." Okay, have stated publicly that passing a bill to implement this is a top priority. The president of the Florida Senate told a local newspaper, "We would be crazy not to pass this bill. Federal highway funds are the source of 30% of Florida's Department of Transportation's budget." A partner as discussing the issues raised by Dua Lipa under the United States Constitution. All right, so can we kind of sum up what we got right here? Wasn't too much, right? This is a tough essay to write. Oh, you guys did write this essay. February 2021. Did anyone sit for this essay? For this year? The reason I say it's tough is because there's not that many glaring issues. They literally tell you not to discuss standing. So what can we discuss? Well, definitely commandeering clause. I mean, that was hugely important. Definitely
Equal protection.
Equal protection, yeah. Who's being targeted? I would say due process. Now this, requiring men to take an 8-hour course. Yeah, definitely that's due process, right? I mean, it's equal protection in that it's targeting them, and it's due process and it's depriving them of their rights not to have to take this 8-hour course. I mean, you could argue it's a takings, but that would definitely fail. Like, it's not taking their property, it's just taking their time.
You can talk about in that as well as like they can be targeting age instead of gender, but if we're on one side, we want a higher test of scrutiny than rational basis for age.
I'm so happy you said that. Of course, we're going to talk about two separately. Is it targeting age or is it targeting gender? And it's two separate levels of scrutiny.
Do you have a property interest in obtaining a driver's license or in your driver's license?
Yeah, that seems some fundamental right there, right? And it seems to be due process. Like, yeah, there's definitely a deprivation of rights there that you have to do something before obtaining or renewing a driver's license that other people don't have to do. I mean, without being able to write too much here, I'm going to write the same mumbo jumbo I write on every one of these common law essays, right? It's maybe First Amendment. Yeah, it's fundamental rights. They're depriving me of my liberties. It's due process. They're depriving me of procedural and substantive due process. It's equal protection. They're targeting me because I'm a man, or they're targeting me because I'm under 34 for one more year. Right? There are some issues that we could have. Definitely commandeering clause. And then I think we'd have to talk about commerce clause, right? Like, that's how they're...
Interstate highways.
Yeah, interstate highways.
Every time I see like highways, I'm already kind of ringing.
Commerce clause, yeah, interstate for sure. Something in the chat. Oh, no worries. Have a great day. Someone had to step out early. All good. I will see you. We'll be in touch. I'll text you, email you. All right. So, anything else that we see here? All of this was really just about the government's argument, right? But I think they're kind of trying to lean you to think that it was okay, but it's really not. I mean, maybe it's okay, right? There definitely seems to be rational basis for it. Like, it'd be hard to argue against it from a equal protection lens, right? And they only need rational basis. That's not that high of a burden. And there seems to be rational basis. It seems like young men, who would have known, are idiots. But it's still probably not going to pass, in my opinion, because of the due process and the commandeering, and there's just too much of a deprivation. But equal protection, maybe, right? Under rational basis, maybe. Under strict scrutiny, I don't believe so.
So I have a question there. So, okay, as far as under equal protection, as far as the age basis, yeah, it's not gonna survive rational basis most likely. But as for the gender aspect of it, if it if it wouldn't meet that aspect of it, you would still say that it might still be struck down, right?
Yeah, it might still be struck down on as not passing intermediate
Right,
school.
unless the government can show that that's a substantially important interest. Blah blah blah.
All you could do is argue.
Argue it. Okay.
Let's see what they did if we missed anything. I love doing this. 2 from Reed, Dua Lipa, good to go. They have standing. So I hate that they talked about assume they have standing. I apologize for this. When they tell you assume they have standing, assume this is a homestead, XYZ, you have to write about what that means. I kind of said, oh, they have standing, let's not talk about it. Now I've just confirmed, and I should have reiterated, you should still talk about it. Unless they explicitly tell you, do not talk about standing. But if they just say to assume they have standing, you have to say, it's important that we assume they have standing because XYZ. In order to have standing, you must have XYZ. Because it's better safe than sorry. And they wouldn't have just shown us this. Here, the facts state that they have standing. Therefore, they must have, all those things that we talked about: injury, causation, redressability. I hate that, but we're gonna feed them that. Taxing and spending, we talked about. Taxing and spending for general welfare is thus afforded plenary power to levy taxes from the states in order to raise revenue for actions that are rationally related to general welfare. Furthermore, Congress is permitted to spend money from the federal treasury in order to provide for general welfare. Congress's spending power also extends its power to allocate funds to several states to serve the general welfare in the states. While Congress is permitted from commandeering state resources and instrumentalities, they, under their spending power, are permitted to condition spending on adherence to government initiatives. So this is literally what we talked about. It's going to be the commandeering clause, and the conversation is, well, they cannot force states to enact laws. They can condition on the enactment, right? Here, all the powers are subject to laws against discrimination. Oh wait, because Dua Lipa properly conditions receipt of funds on a rational government purpose for providing for the public welfare is a valid exercise of the taxing and spending power. So that they're arguing what Joel was saying, that it's okay because they're just conditioning it. They're not inducing it. I mean, they're not compelling it. They're just inducing it. But again, I think it's a fair argument to make that it might as well be, but you argue both ways. So it's subject to anti-discrimination laws and is in violation of them. Commerce clause we talked about, taxing and spending, they can regulate under the commerce clause. The instrumentalities, non-commercial activities that substantially impact interstate commerce in the aggregate. Here, that's proper exercise of the commerce clause. I think we're all good with that. Equal protection. Here's where we get into the problem. It violates equal protection under the 14th, incorporated to the U.S. government by the 5th. Equal protection provides that every U.S. citizen is permitted equal protection of the laws. The Supreme Court has identified the suspect classes, strict scrutiny, and here, intermediate scrutiny, and then rational basis. It targets gender and age because it's men and under 34. Men will be intermediate scrutiny. Therefore, they have to prove that substantially related to important government interest. They just kind of go through it, that it's violative of equal protection. Then based on age, you're going to go with rational basis, right? Age will be up, that's what they said. Literally what we kind of argued, Joel, perfectly. That if it was just based on age, it would probably be okay, rational basis. But if it's going to be on intermediate scrutiny, it's probably going to be struck down. That's a fair argument. And then due process. This is what I was saying. I was saying this is definitely going down with due process because, process that is due, which generally includes notice and a hearing. So substantive and procedural process provides that the government may not deprive persons of life, liberty, or property without due process of the law. Citizens have property rights to public jobs, benefits, and licenses. Substantive due process provides that a person may not be deprived of a fundamental right without due process of the law. Right to vote, right to freedom of speech, right to privacy, interstate travel. The right to privacy includes, camper, contraception, marriage, procreation, education of children, child rearing. Substantive due process is strict scrutiny. Government must prove that it's necessary to achieve compelling state interest. Here, depriving them the right to a driver's license without due process. That's what we were saying. Fundamental right, namely the right to interstate travel. We did touch on that, but that's a good one. That's smart. Yeah, that's the smartest way to put it. We touched on it, but we didn't get to it as well as they could have. That it is a deprivation of your right to travel by making it too difficult for them to get driver's license. Anti-commandeering. Furthermore, they may not commandeer. We talked about that. And then they also seemingly have talked about the police powers. It violates the principles of federalism. It provides the states are not to encroach. That was good. Amy, I think you said encroachment on the federal government's power, and the federal government is not to encroach on the state's power. States, not the federal government, have police power. This means that states are afforded the sole power of legislating for these citizens. The state's police power generally includes this or that. Here, they can argue that it violates federalism by encroaching on states' police power. We kind of mentioned this: federalism, state supremacy, 10th Amendment. States, not the federal government, have the power to regulate driver's license. Cool. And then the anti-commandeering. So last, but certainly maybe not least, I just want to look at the model answer issues. This is just one more that we could see. It was a con law essay. And then what did they see? We saw that there was many problems, right? Many problems with this act. And clause 1, it attempts to modify the appellate jurisdiction of the Florida Supreme Court. The Florida Constitution gives the Florida Supreme Court the discretionary jurisdiction to hear appeals from the district court's appeals for a variety of reasons. So it's talking about what the Florida court has original jurisdiction over. This is an important sentence. I know it's not the most important sentence, but it's something to leave class with on a note of learning. The Florida Supreme Court has mandatory jurisdiction of appeals arising out of district court of appeals relating to bond validation proceedings, imposition of the death penalty, and the invalidation of a statute or constitutional provision. So there was a violation of that right here. The Florida legislature may not extend or enlarge the discretionary jurisdiction of Florida Supreme Court as constitutionally mandated. So this clause is unconstitutional because it attempts to do so. In contrast, in the federal Constitution, Congress has the power to enlarge or reduce the appellate jurisdiction of the U.S. Supreme Court. That's true. If you take MBE questions, that's a common answer, that Congress can enlarge or reduce the appellate jurisdiction of the U.S. Supreme Court. But they're saying here that that's not the case in Florida. So the Florida Supreme Court has mandatory jurisdiction over bond validation proceedings, imposition of the death penalty, I could see that coming up, and invalidation of a state or constitutional proceeding. What else do we have right here? Attempts to create a way to modify the creation of rules of procedure created by the Florida Supreme Court. Normally, the legislator passes a bill by majority of each house and then presents to the bill or governor to veto or sign. Under the Florida Constitution, however, Florida Supreme Court has the exclusive authority to create rules of procedure for the Florida courts. The legislator may reject such rules created by the Florida Supreme Court by a 2/3 vote, but the legislator may not amend or modify such rules. The Florida legislature has no power to create rules of court procedure, as this power is exclusively vested in the Florida court according to the Florida Constitution. So this was, again, separation of powers encroachment. So it's unconstitutional, violates the separation of powers. So we saw a separation of powers issue. We saw a problem with the original jurisdiction of the Supreme Court. This is kind of a newer thing, but good to see. Here, medical malpractice. Florida Constitution guarantees its citizen access to courts for all actions at law. The legislator may not deny access to its courts without providing a reasonable alternative unless it can justify with a compelling governmental interest, like the Kluger Doctrine. So this was access to courts. So that was definitely something else that came up, was access to courts. strict scrutiny test, narrowly tailored, and things like that. This runs afoul of the Florida statutes, which mandate procedure for medical malpractices, because it's a separation of powers issue. And then here, different subject. I really want to point this out. Florida laws have to be focused on a single subject. The single subject rule exists to provide notice and ensure that each title adequately describes what's contained with the statute. The act contains, so right, we have to have that single subject. So it violates a single subject. All right, that was a pretty tough one, and it's fair to end that on a tough one because con law is tough. There's, we hadn't seen anything about mandatory jurisdiction, and I'm sure a lot of people missed that, but it's just another piece that you could get. So what I would highly recommend, as we create this class folder, it'll be updated to include all of these essays, just like, I'll give everyone a quick example. Just like we did with the materials for Florida contracts, it has all the materials that we went over from class, and then it also has the folder that has all the model answers, all the essays and model answers. And I would include the official essays and model answers in your study regimen, not just going over the materials, not just going over the videos, but also going over the model answers themselves, because that's provided by the Florida Bar. So any questions from anyone in the audience? Super fun day. I'm gonna go ahead and stop this recording.